Okay, I wanted to provide a quick video that goes over the elements of the amicus brief as you're working on them based on examples I've received from students, and then I want to show you kind of what's working, what's not, and then how to proceed working forward. We want to think about the cover page here. I blurred out the EMPL ID number and the student name to protect the privacy, right, of the students. But you want to make sure you've got your EMPL ID at the top, you've got your student name, brief of, right, you put your name, and then your email address, which both students in this case did correctly. However, you should see, right, the big difference. On the left, you've got a case name, an actual case, and this should be the case that you're building from, the one that you're agreeing with or disagreeing with, depending on whether you're petitioner or the respondent, versus this other one here where it's been blank. They haven't put in the case name, and this makes me worry that they don't have a case in which they're arguing from. From here, you want to develop your arguments, right? So the table of contents is going to be finished after your brief, but this student, I think, did a good job of basically, here's what I've got so far, and then if the pages change, which they shouldn't change too much, but if they change, then you can go back through and update them. Another student has an interest statement here that is very kind of based in personal experience, and it says why they're working on this particular issue. In the table of authorities, I've got two examples here of some kind of a mix of correct and incorrect. So the first thing here is it's incorrect. You want to list the pages where they come up in the brief. So there's not 698 pages in your brief, and so I shouldn't see numbers like that. The student put the pages that it's found in the case, but what we want is where does it come up in the brief. We want statutes, not statues, right? Make sure you've got that spelled correctly. And then state laws and regulations should go in the statutes section, not in other authorities section. Also, if you're going to say something like drug treatment prevention programs, you actually need to list, is it a website, is it a pamphlet, right? What do you mean? So you have to provide the actual information. So if it's a website, right, you just put the web address in there. And you want to make sure you have all four of these categories. Now, on the other hand, you see on the right-hand side, we've got this kind of correctly set up, right? There's a nice looking blue book citation, and they've got the page number in which it appears. This is so that the person can look up the case and also see where does it appear in your argument or in your brief. And then they do the same thing for the statutes and the constitutional provisions and the other authorities. The only issue here is that the 8th Amendment prohibition, that's not a statute, right? That would show up in the constitutional provision. And if there's something else that they're intending, that should probably go in other authorities, if maybe it's from a website or some policy brief, maybe that they did. Other authorities would also include articles, any research articles you find, again, websites, news articles, anything that you find that you think is relevant to the brief. Now, as you work on your arguments, I need you to remember these are legal arguments. These aren't your personal opinions. So it's not that, I have to say it this way just so that it kind of registers. It doesn't really matter what you think. That's not what legal writing is. Legal writing is using arguments that have been framed already by the courts, and you're going to use those to support your position. So you're going to pull these from the cases you research. You're going to start with your first controlling case. You only need two arguments. You're probably going to find two arguments in the controlling case, but you need to, as I'll show you in a second, look at the other cases to develop those arguments. And so if you look here in the example amicus brief that you had in week 6, you can see, right, they've got this kind of broad statement of what they kind of want the Constitution to protect, and then they go into details on what does this mean according to the courts, right? So, for example, there's quoting here to Justice Blackmun from this case, Victor versus Nebraska. They're not coming up with their own idea or their own opinion, right? They're reminding the court that this is important to the court, and that's really what legal argument is. Now, this also relates to something you've probably heard before but didn't know how to do, is stare decisis. Like maybe you memorized the definition, got an A on the exam, but you actually had no idea of how to apply it, which is really what we're seeing. Can you actually apply legal research, which is a learning outcome for both the Justice Academy, criminal justice majors, but also for this specific class. This is what you're supposed to be able to do in this class. So this is from, I have an in-person version of this class, and so this is what they're doing and what we just did yesterday actually on the board. And so they started with their controlling case. In this case, they're using a case called Graham versus City of New York. They're looking at police excessive force. And so you see their criminal justice issue here on the right-hand side. and they were able to look through the case and pull out the three main issues, or the three main elements that are important when you're arguing for or against excessive force. They also were able to find from the case the statutes and the regulations. This also was in the Dr. Chapman reading, and so a couple students were able to put those pieces together, which of course made their lives a lot easier, because now they're just copying and pasting from the case and then from the Chapman reading, and then they're just making sure they include that in their statute of authorities. Now, in every one of the cases, you're going to see that there's going to be for, and they're going to provide cases and arguments, and there's going to be against, and they're going to provide cases and arguments, right? Remember, the arguments come from the cases. And so what you're doing is you're synthesizing. You're taking the pieces you need from those arguments and you're using them for your own argument. So in this case, if we go over to the right-hand side, they used two arguments that came from other cases. One's defining what an unreasonable traffic stop is, because then that goes to the first element of a crime leading to arrest. So a traffic stop is not a crime that should lead to excessive force. In argument 2, the person did not pose an immediate threat and did not resist, and so that goes to the second elements. And again, these come from cases, and so they copy and paste the language of those cases into their briefs. Now, they also were able to recognize, it did take them a while, but they were able to recognize from the Chapman reading that qualified immunity would be the counter argument in this case. So they have to be able to respond to that defense that the police are defying and say this is why it shouldn't be qualified immunity, and that's what they're kind of working on right now. Now, you also want to think about policy arguments. It's something that they're researching. Several of them are doing this and trying to include that into their articles. So they're looking at the ACLU, they're looking at some criminal justice resources, and they're just kind of trying to figure out what are the policies on excessive force. Now, I just want to give you an example of what we mean, right? So here would be my argument using the template I provided for you. I have kind of a broad statement of what I think. Courts have found the excessive force violates a person's constitutional rights. But then I just copy and paste from over here, from the actual case, right? And so these are the things that are important that I need to be able to show whether excessive force was used. Then I go ahead and I pull up this case, Tracy. I click on it, right? It pulls it up. I read through and I find, oh, the court found that Officer Freshwater used excessive force when he sprayed Tracy with pepper spray. Well, I look in the Graham case. What was excessive force in that case? Well, it's when he was dragged from his vehicle, shoved against it, and then handcuffed behind his back. In both cases, the court found that use of force may only be used in three elements listed above. In neither case was the person posing a serious threat or evading arrest. So this is what I'm really looking forward to see how you do. This is what I'm going to be grading you on. It's not going to be on all the formatting and on that. It's going to be on whether you're able to use the arguments from existing legal cases in a way that applies to your central issue. That's really the test of this, right? So if you're writing this like an English paper or a sociology paper where you're talking about your opinion, then you're doing this wrong. You need to be able to literally copy and paste from other cases that are similar to each other. Now, in this counter argument response, all I have to do, right, is go to the Chapman article, and I've got really good language that he uses on telling me about what qualified immunity is and when it shouldn't apply, and then he's giving me more cases, right? So again, these all go in my table of authorities, and I just pull the language out, and I would just combine my arguments 1 and 2, and I would use that to establish my counter argument. This would be the shortest, I think, because I don't really have to go too far because I've already said what I need to say in argument 1 and 2. I'm just addressing this idea of qualified immunity. And then finally, you have to tell the court what you want. What are you asking for? So in the example reading that you were provided for, they said the court should reject the Attorney General's request to construe the statute, right? Construe just means interpret, and so that it doesn't, take their issue out of court and it keeps it in the court, right? So again, this is just an example of asking the court or telling the court what you want using the cases and using the statutes. That's really what you're being graded on. If you're trying to do it any other way, you're kind of banging your head against a wall and making life a lot harder for you. So you'll complete that final assignment, ask me some questions. I can try to respond to those next week, but this gives you an idea of where you should be going, and for those of you who have been on the right track, this will help you just go ahead and finish, and you want to submit that next week. All right, thanks a lot.